Supreme Court every year dabbles in employment law, and usually they mess it up for us. And they give us a lot of rulings that we don't like and expand coverages. Well, finally this year, for the first time in quite a while, we got a few good decisions out. So we wanted to share those with you. I'm sure most of you deal with employees. If you don't deal with the employee issues yourself, you have to deal with them in some aspect of working with others. And today we're going to talk about a few cases that should help you in dealing with employees. The first case we're going to talk about is Vance versus Ball State University. How many of you dealt with a hostile work environment? Anybody ever had any hostile work environment, sexual harassment claims? I think Karen and Shannon may have seen a few. Well, if you know, hostile work environment is started under the guise of sexual harassment, but it has been expanded to all protected classes. Therefore, it can be a hostile work environment based on your race, based on your age, based on disability, under all the protected classes. And the hostile work environment, in Title VII claims, the liability is based upon the position of the harasser and the result of the harassment. And one thing that we see here is if the harasser is a supervisor and there's a tangible employment action, then the employer is strictly liable. Meaning, basically, if a supervisor harasses your employee and the employee quits, terminated, is demoted, they suffer a tangible employment loss. When you call us, all we can do is start trying to work on the damages because you're strictly liable. You are absolutely liable for a hostile work environment, and it's now gone into a damage issue, and how can we mitigate those damages and try to reduce those potential damages that you will have to pay. If the harasser or the supervisor has not been a tangible employment action, you have an affirmative defense. And there's two prongs to the affirmative defense. One is, have you exercised reasonable care to prevent and correct any harassing behavior? How many of you have an employee handbook? Most of you. Sexual harassment training. Those are the things that usually come under step one. You have a policy that says this is the type of activity that's prohibited. This is what you should do in the event that you are subjected to a hostile work environment. This is what you should do if somebody comes to you and complains about a hostile work environment. That is the first step. Second is you have to take corrective action. In other words, if someone comes to you with a complaint, comes to you with an issue, you have to take action to correct it, and it needs to be prompt, and it needs to be effective. For example, if someone comes to you and says, Bob is sexually harassing Jill, and you go tell Bob to stop, and you find out Bob continues to do it, well, you took action, but it wasn't corrective. It wasn't remedial. They didn't stop it. You have to stop that action. Finally, coworker harassment means the person who is not a supervisor. Those individuals can also you can also be liable for their actions if you knew or reasonably should have known. And those are usually the cases where it's pretty much outright and outrageous. You see it all the time. There's been complaints about it. You hear about it. Everybody talks about it. In those cases, it's a negligence standard. And if you fail to take corrective action once you hear about it, then you are, again, can be held liable. So the big issue became, well, what is a supervisor? And as you can see, the EEOC has a broad definition of who a supervisor is, and they had a decision that says individuals who are authorized to direct another employee's day-to-day work activities, even if they didn't have the authority to undertake or recommend tangible job decisions. So the supervisor was very broad under the EEOC definition, and a lot of courts followed that. However, a few circuits did not. Because the EEOC guidance was not the law, circuits like the 7th Circuit over in Indiana, they didn't follow that. I will tell you that Kentucky and the 6th Circuit did follow the EEOC's broader standard. So in this case, the Supreme Court took a look at the issue and decided a person is only a supervisor if he or she is empowered by the employer to take tangible job action. In other words, they had to have the ability to affect a significant change in your employment status, hiring, firing, failure to promote, demotion, assignment, affect your assignment with significantly different responsibilities, things of that nature. It had to be someone who really had supervisory power in order to constitute a supervisor. And the reason why this decision is good is because it limits the amount of individuals within your organization who's going to be able to make you liable, strictly liable, of course, or subject to the affirmative defense when you have a situation. One thing we recommend, how many of you use job descriptions? A few of you do? Job descriptions are going to be important, but not dispositive. It's really going to be about what the person is doing, what their responsibilities are. But we like to have the job descriptions, if possible, that sets out supervises these positions. They're supervised by this position themselves. It breaks down the levels and the hierarchy of the environment, breaks down the duties. And if you have those, that'll be very helpful in determining who is and who's not a supervisor. And as we said, as fewer employees are likely to be able to bind you based on that. And one thing the court said was, which we like to hear, this is going to be helpful for employers for summary judgment. So in the beginning of a case, you'll pretty much know who's a supervisor, who's not. Shannon and I tried a case a few years ago, and that issue went all the way through the trial. So we had to argue, well, if they're a supervisor, then there's this. If not a supervisor, then this is the standard. So you got to present both to the jury. Under this standard here, I don't think any of those people would have been supervisors under this new standard. And the case would have been a lot different, and it would have been a lot different that we had to present to the jury. So this is going to be very helpful for employers in the future. Any questions about supervisors? Have anyone ever dealt with harassment by a supervisor? No investment? Oh, you guys have good employees. Another case we want to talk about is how many of you have dealt with retaliation claims? Any retaliation claims? Retaliation claims have become the new rave. Now it's become one of the biggest groups of employment law cases. There's more retaliation cases being filed than most other protected classes with the exception of race. And what the retaliation prevents is somebody who has been opposing unlawful employment practice, or he or she has made a charge with the EEOC. Anybody had EEOC charges? Kentucky Commission on Human Rights? These are good employers here. Wow. Wow, I'm going to be out of business soon. No, that happens in these places. And then, or you assisted or participated, meaning you're a witness. You came and said, this person's been harassed, this person's been discriminated against. And if a person is retaliated against for making such a complaint, then they have a cause of action. Over the years, the courts have had a bunch of different standards. It's been a motivating factor, a substantial motivating factor, the but-for cause and the sole cause. Again, Kentucky was on the looser end of this. We were doing the substantial motivating factor, which meant basically it didn't have to be the sole factor, but if there was some substantial basis for it, that was part of the reason, you probably could get to a jury, if not get a summary judgment as an employee. The court took a look at this and decided that the Supreme Court said but-for causation is going to be the standard in retaliation cases, meaning literally, but for this, you would not have been terminated. And that's very different from status-based discrimination, in that it only has to be a motivating factor. For example, if you're terminated because you're a woman or because you're a man, clearly you have that. But if that's part of the issue, you can get past it. You can say, well, that was part of the issue. They looked at your race, they looked at your sex, so it's a substantial factor there. But in retaliation, it's got to be because of. It has to be absolutely because of. And what that allows you to do is, if you're documenting, you're able to show the reasons why termination happened, and that if you can show that we've terminated, say, several people for this same reason. For example, if someone has, say, 5 tardies, and you can show, I've terminated everybody who had 5 tardies, this person had 5 tardies, they shouldn't be able to show that but for their complaint, they would not have been terminated. And one thing, again, the court here was really focused on, the court seemed to be really focused on some of the issues they see with summary judgment and a lot of frivolous claims. What the court said that this was going to help because there'll be fewer cases where the discrimination claim fails, but the retaliation claim survives. And why this was important is, in a lot of these cases, including this Supreme Court case, an employee often will say, I was discriminated against because of my race. I complained about it, and they terminated me because I complained. Well, the courts were throwing out their discrimination claim saying, well, it wasn't racial discrimination. But it's an issue for the jury whether or not you were fired for complaining about it. And the court found that to be kind of an oxymoron, that you weren't fired for discrimination, but you were fired because you complained that you thought you were discriminating. And so the court said this is going to clear that up. Also, the court recognized that in certain situations, an employee who say, for example, you've had that sit down, listen, your employment's pretty, your performance has been pretty bad, your attendance is bad, the quality of your work is bad. If you don't shape up, we're going to have to let you go. Well, then the next day they go to HR and say, you know, I've been having all these problems since I've been here for the last 5 years. I've been discriminated against, etc. And then when the employee gets terminated based on the same performance issue that had already been discussed, they say, wow, it was retaliation. I went and complained to HR. About a week later, I was terminated. And the court says, this is going to get rid of those cases because you'll be able to show that it wasn't the but-for cause. So again, what we always recommend here is document, document, document. If you have your documentation, that goes a long way. If you can show, I met with you in January about your performance, I met with you in April about your performance, I met with you in July about your performance, you went the day after to HR, said you were having these issues, and then in August, you continue to have the same performance problems and I fired you, this will be able to show that it wasn't the but-for reason, didn't have to be the complaint, but you have this history of performance problems. So remember to document everything. Document everything. We always recommend, if you're meeting an employee and it's an important enough issue, write notes, take down, put either an email or just a little letter together of these are the issues we talked about, here's how we talked about addressing those issues, and just date and sign that you had the communication. And sometimes employees will refuse to sign. I put refuse to sign, put the date down there, maybe have another witness that they refuse to sign. Anything that shows the temporal proximity of when the conversations occurred will help you there. But like I said, the email is always a good version because of the date stamp. The last case we're going to talk about, anybody heard about the Defense of Marriage Act? The Defense of Marriage Act, this is the most recent decision to come out that talks about, one of the areas about the FMLA is one of the big issues this comes out for us, and the Defense of Marriage Act defined marriage as a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex who is a husband or a wife. The problem with the Defense of Marriage Act is, if you didn't know this, which I didn't until this case came out, that definition applies to a little over 1,000 statutes and even more regulations. So that definition applied to a lot of things. In this particular case, we had a same-sex couple, and when one of the spouses died, they were properly married under New York law, residing in New York. And when one of the spouses died, they attempt to use the estate tax benefit of being able to claim a certain exemption. The court said because that's a federal tax, they said it did not apply, charged over, I think it was close to $400,000 in taxes that had to be paid just because it was a same-sex couple. And this definition applied to any act of Congress, any federal law that talks about marriage or spouses. The court ruled that it was unconstitutional, and it imposed a disadvantage, a separate status, and so a stigma upon all who enter into same-sex marriages made lawful by the unquestioned authority of the states. One of the big issues the court looked at is marriage has always been defined by states, and so the federal government stepping in here violated the Equal Protection Act and subjected this class of individuals into different standards when it came to several laws and several benefits that others were not being subjected to, even in states in which they were actually being married and living and residing in accordance with that state's law. So, again, over 1,000 statutes and regulations applied. Immediately after this decision, the Department of Labor issued a stance that same-sex marriage couples, if anybody use FMLA or deal with the FMLA, if you're in a state, and we have a list of them here, if you're in a state that allows same-sex marriages, same-sex couples to receive benefits, then the FMLA, you can take out time for the serious health condition of your same-sex spouse. And as you notice, there's 12 states that are there. As we know, there's an issue right now with New Jersey. The judge has said that it is allowed, and the governor is challenging that. But this is very broad-reaching because COBRA benefits, most people get COBRA. If you get laid off, you lose your job, you can take those benefits for a certain amount of time, not just for you, but for your dependents. Well, in states that have same-sex marriages, that means your same-sex spouse could get those health benefits continued too. Kentucky is not one of those states, and within about a month of this decision, there was actually a case in our state circuit court here, Jefferson Circuit Court, in which the judge ruled because Kentucky does not allow same-sex marriages, that this decision did not apply. So, any questions there? We're going to turn over to Rebecca, who's going to talk about a couple other cases.
I let Dee do all the Supreme Court cases because he thinks he's the supreme member of the Employment Law Service Group. So, well, the Kentucky Court of Appeals, we let him think that. We let him think that. That's right. So,
I'm going to protect him.
yeah. Okay, well, the Kentucky Court of Appeals just this summer in July came out with a decision that's sort of new. Just to give a little bit of background on disability discrimination law, there's a federal law, the Americans with Disabilities Act, and then also a Kentucky counterpart, the Kentucky Civil Rights Act. And both of those prohibit disability discrimination in the employment setting. So the Court of Appeals in Pennington versus Wagner's Pharmacy basically decided that if you are morbidly obese, that constitutes a disability for which you cannot discriminate against an employee under either law. They were really looking at the Kentucky law, but when they're applying the federal law, they will probably apply that same standard in Kentucky courts. And just to give a little bit of background, too, on the changes in the ADA that have happened really within the past 5 years. In 2008, the ADA Amendments Act was passed on the federal level, and it really gave a broader scope to what constitutes a disability for purposes of the law. So it's basically defined as a physical or mental impairment that limits you in a major life activity. And physical impairment was typically defined as some sort of physiological impairment, that kind of thing. And you'll see where that plays a part in the court's analysis once I get there. But to give you some factual background, so the plaintiff, Melissa Pennington, was a food truck operator for about 10 years for Wagner's. They worked on the backside of Churchill Downs. And she had been obese all her life. She weighed 200 pounds at the age of 9. And at the time she was fired, she's 5'4", weighs 425 pounds. Well, one day she went in to pick up her paycheck, and according to her, she was a little bit disheveled that day. She was moving residences. She had some big bags under her eyes, and the supervisor saw her and later informed her manager that they needed to terminate her because of her disheveled appearance. The co-workers claimed that they heard from the manager, who ended up having to fire Pennington, that the manager said she was fired because she was overweight and dirty. So there was a factual dispute about what the actual reason was for terminating her, but according to Pennington, it was because she was overweight and dirty. The American Medical Association labels morbid obesity as a disease, but despite that, and the trial court basically said, well, this is not a physiological disorder, and consistent with several other courts who had looked at this issue in the past before the ADA Amendments Act, they said, you know, the obesity isn't a secondary result of a physiological disorder like diabetes or hypothyroidism or something like that, so it's not a disability, you don't have a claim, your lawsuit goes away. So she appealed to the Court of Appeals, and the Court of Appeals relied on the testimony of an expert who said that obesity can be caused by a cluster of often unknown physiological abnormalities. And on that basis, the Court of Appeals overturned it and said, no, Kentucky recognizes that if you are morbidly obese, you are disabled. So there's a difference between being overweight and morbidly obese, and the court did talk about this in their opinion. Basically, you are morbidly obese when your weight is double your normal weight, or you're at least 100 pounds more than what a normal weight should be. If you're just overweight, it might not be a disability, but they could have a disability if they have some other condition, just something that you have to look at. There are several other courts that have followed this trend throughout the country in the past few years, and it just so happens that Kentucky picked up on it first, and we're not last and not following California like we normally do. So, but, you know, Louisiana, Mississippi, Pennsylvania, New York, Montana all have held similarly and said this morbid obesity standard with 100 pounds or double your body weight, you have a disability, and your employer cannot discriminate against you on that basis. So what does that mean? You know, the disability rules, I mean, I think Dee covered them pretty well before, but you can't refuse to hire, promote, train, deny pay or benefits, terminate them like they did in this instance. And if there's a way that you can accommodate them, I know the expert in this case said sometimes people have difficulty tying their shoes or they have hygiene problems. The bags under her eyes were actually because she has diabetes, and so that showed up. You have to be careful about discriminating based on their appearance, and so if somebody can't tie their shoes, you know, you might figure out an accommodation with them if they need to have their shoes tied for their job, but just something to be aware of. It could have a lot of implications in terms of accommodating the employee's disability and be aware of that moving forward. So that's just an interesting Kentucky update. I also wanted to update on a presentation that Shannon made last year, which is the EEOC's big focus on criminal background checks. In 2012, they issued some guidance that said employers cannot have a blanket policy prohibiting hiring folks if they've been convicted of a crime, and that it has to be an individualized assessment based on what the job requires. So if somebody, has an assault charge and they were convicted of that, but that's not going to be in any way related to their job duties, and it won't put the employer at risk, then you probably can't discriminate against that person in the hiring process solely based on their conviction. And basically, a prior arrest alone is not enough. You can't discriminate on that basis either in hiring. That's the EEOC stance, and this year we've seen the courts sort of weigh in on that a little bit, although you'll see that it's not exactly decided. But right now, the EEOC has been losing their battles on this issue. So a couple of cases recently in August and October, the courts have rejected the EEOC's position. Now, these cases have been going on for a while, but it's interesting that these decisions are coming down after the EEOC's guidance came out last year in 2012. EEOC versus Freeman. Freeman actually had a background check policy that they used only after offering someone the position of employment, and it was very detailed, very tailored to the person, and so you would think that it would follow what the EEOC is looking for from employers in these cases. But nevertheless, the EEOC went after Freeman and said, no, the fact that you even have this background check policy in place is having a discriminatory impact in your hiring, and it's disproportionately excluding traditionally Hispanics, Latinos, and blacks from your hiring process. And it's that effect of disproportionately excluding those folks because they tend to have higher conviction rates, right? So that's the discrimination side and theory to it. The court came down and said, no, they've tailored this. They extend the offer to people first, and we're kicking this case out on summary judgment, so it never even got to trial. So that's a win for employers. EEOC v. PeopleMark, that is actually a Sixth Circuit case that has been going on for 8 years, and PeopleMark is a temporary employment business, and they hire a lot of temps, and they had a policy, while the EEOC said that they had a policy that blanket excludes people who have prior convictions. Well, after years and years and years of PeopleMark saying, no, we don't have this policy, it's not written anywhere, they went through a ton of discovery, 18,000 documents, countless depositions. The court finally said, no, they don't have this policy. Nevertheless, the EEOC continues to litigate, changes their theory, and says, well, even though they don't have this policy, it still has a discriminatory impact somehow, the way they're hiring people. And that was dismissed, and then on October 7th, the Sixth Circuit actually upheld a $750,000 award to PeopleMark to reimburse their attorney fees from the point that the EEOC continued to litigate after they said, no, this policy isn't in place, PeopleMark doesn't have this policy at all. So that was, again, a win for employers. However, I would caution that that's probably an anomaly, and it's also a cautionary tale because PeopleMark had to litigate for 8 years, and they didn't get all of their attorney fees recovered. Only they had to pay for everything up to the point where the court said, no, PeopleMark does not have this discriminatory policy in place. So, but cautionary tale again. There's a Pennsylvania state court case that was just came down in September, and it's based on the state law. The EEOC is not involved, but there's a state statute in Pennsylvania that says during the hiring process, you have to tailor your background checks to the specific job and whether the individual is qualified for the job. In this particular case, they had actually hired the individual, received the criminal background information before the individual was hired, and then terminated the individual about 2 or 3 months later based on the criminal background information. And the employer tried to argue, well, we looked at it after they were already hired, and the statute just deals with hiring, so they got it kicked out. The Court of Appeals said, no, because you got the criminal background information during the hiring process, they could have a claim, so we're going to let the plaintiff proceed with their lawsuit. And then the EEOC also filed 2 lawsuits dealing with this discriminatory pattern and practice based on policies that they believe are discriminatory and exclude people improperly based on their criminal backgrounds. Those were filed in June. One is against Dollar General, and that is in South Carolina and still pending because, you know, it was just filed in June. And then the Dollar General one's in Chicago, and then another against BMW. That one's in South Carolina. So both of those are pending. There could be a lot more litigation about this issue. In fact, I anticipate there will be, but it'll be interesting to see where the courts come down against or for those 2 employers. So those are just some non-Kentucky, or one Kentucky, and then some more general updates with the EEOC and how those battles are going with the criminal background checks. Any questions? Yes.
Okay, I'm a little unclear. That in Kentucky, am I allowed to discriminate based on a felony conviction or not? I mean, can I not hire someone based on a felony conviction, or would you recommend I not do that?
I would recommend that you make sure that that is tailored. The conviction would be a problem in the job. So let's say somebody has been convicted of embezzling before, and they're going to be handling a lot of money in the job that you're looking at them for. That might be a problem. They could have the propensity to do that again, right?
Well, then I can argue that any felony is a propensity that they're a dishonest individual.
You could try to tie it. Yeah, well, that's when you call your friendly employment lawyers. So, yeah, that's right. Well, and you know what? It's funny because it's actually a catch-22 for employers. We see this a lot with sexual harassment type cases because under the common law in Kentucky, if you hire somebody with, let's say a sex crime background, and that you could be liable to the person that they commit another crime against while they're working for you based on negligent hiring or supervision, that kind of thing. So it's a really tough position. I know, I think there are 9 state attorney generals that are fighting this, especially for like the police force, that kind of thing. They don't want to hire cops with a criminal background. So
I didn't think convicted felons were a protected class.
Well, the EEOC thinks they are, so I don't know. We'll have to see how this plays out.